Question number 1. Write the definition and types of artificial insemination. Discuss the indication, biological and legal aspects and precautions of artificial insemination. First of all, what is the definition for artificial insemination? Artificial insemination is nothing but artificial introduction of semen into the vagina, cervix or uterus to produce pregnancy. So, there are 3 types of artificial inseminations. Number 1, artificial insemination homologous or otherwise called as artificial insemination husband. Second type, artificial insemination donor. Third type is nothing but it is a pooled donor semen which is composed of donor semen to which semen from the husband has been added. Let us see about the indications of artificial insemination. Artificial insemination is done in case of impotent husband if husband is unable to deposit the semen in vagina due to hypopadiasis, that is the urethral opening at the undersurface of the penis, or epispadiasis, that is the urethral opening present at the upper surface of the penis. This is an congenital defect. And this artificial insemination is done if the husband is sterile and when there is RH incompatibility between husband and wife and when the husband is suffering from hereditary diseases. Coming to the precautions. There is no precautions in case of artificial insemination homologous. Only these precautions are applicable for artificial insemination donor. So here the first precaution is consent of donor and his wife is essential and identity of the donor must remain secret. The donor should not know to whom the semen is donated and the result of insemination. See, the donor must be mentally and physically healthy and should not be suffering from any hereditary or familial diseases. The donor must not be a relative of either spouse. He should have had children of his own. The race and characteristic of the donor should resemble that of the husband of the woman as closely as possible. The donor should be the same blood group as that of husband. There should not be any RH incompatibility between the donor and the recipient. Okay. Then the physician should have the permission to use his own best judgment in selecting the donor. The couple should be psychologically fit and emotionally stable. The woman to be inseminated and her husband must give consent in writing that an unknown donor should be used. A witness must be present when insemination is done. And the next point is, it is usually wise to use pooled semen. When husband's semen is mixed with that of the donor, there is the technical possibility that the husband may in fact the father of the child. The physician who administers the artificial insemination should avoid delivery of the child. Usually, a single donor semen is not used to produce more than 10 children. So, these are some of the precautions that should be considered before doing artificial insemination. Coming to the biological aspects. Semen is obtained by masturbation. 1 ml is deposited by means of a syringe in or near the cervix. And ovum can survive in a fertilized form for 12 to 24 hours after it leaves the ovary. The power of sperms to fertilize is usually retained about 48 hours after insemination. The usual time taken by sperms to travel from vagina to the fallopian tube is 6 to 24 hours. So because of this problem of timing, insemination on several successive days in the month increases the chances of pregnancy, and successive rate is only 30 to 40% within 3 to 4 months of the start of the treatment. Frozen semen of artificial insemination donor is increasingly used nowadays. So this is the process of preparation of the frozen semen. Semen is added with glycerol and slowly cooled, then rapid freezing and stored at minus 196 degrees Celsius. Next, coming to the legal problems encountered in artificial insemination. So there is no statutory law in India for artificial insemination, and no legal problem will arise in case of artificial insemination homologous. In this case, the husband's semen is used for artificial insemination, so there will be no legal problems. But the legal problems are seen in artificial insemination donor. So the legal problems are adultery. Number one, adultery. The donor and the recipient cannot be held guilty of adultery in India as per the section 497 IPC, because this section requires sexual intercourse as necessary part of adultery. Here in this artificial insemination, there is no sexual intercourse between the donor and the recipient, so they are not held guilty, and it has been decriminalized, and it can be the ground for divorce. And then coming to the legitimacy, the husband is not the actual father of the child born through the artificial insemination, and as such the child is illegitimate and cannot inherit the properties of the father. And the third most important legal problem is nullity of marriage and divorce. So what is nullity of marriage? So there is an act, there is a Special Marriage Act which is created in 1954. The act says either party has a living spouse, either party was incapable of giving valid consent due to unsoundness of mind or mental illness, or unfit to procreation of the children. Parties are underage, parties are in relation of a prohibited degree. Under these circumstances, nullity of marriage can be considered. And here the problem arises when mere artificial insemination is not a ground for nullity of marriage or divorce, because sterility is not a ground for it. So however, if artificial insemination is due to impotence, it is a ground for divorce or nullity of marriage. Consent of husband in case of nullity of marriage has no bearing in this. When artificial insemination was done due to impotence of the husband, the wife may ask for the nullity of divorce even if a child was born out of this artificial insemination donor. And if artificial insemination is done without the consent of the husband, he can sue his wife for divorce and doctors for damage. Then coming to the next legal problem, natural birth. So here what happens is, if a child is born naturally, after some times the birth of a child through artificial insemination, the status of the child born after insemination remains illegitimate unless it is adopted. Unless the child is adopted, the status of the child born after artificial insemination is illegitimate, and the status of the child that was born through natural childbirth remains legitimate. So, but if the parents do not declare the artificial insemination, the child remains to be natural child for practical purpose. Then coming to the next legal problem, an unmarried woman or widow may have a child from artificial insemination, but that child would be illegitimate. And then coming to the incest. Incest is nothing but illegal sex between members of the same family, example brothers and sisters. So here in artificial insemination donor, there is a risk of incest between the children born by artificial insemination and the children of the donor. But this is not an offense in India.